If you or your loved ones are waiting for a family-based green card or planning to start the process in 2026, you need to hear this update. USCIS has just announced changes that could affect processing times, eligibility requirements, and how petitions are handled. Some families may benefit, others might face new steps, and being unaware could cost months, even years, of waiting. This isn't meant to scare you. It's meant to help you act smart and stay ahead. Let's take a slow, calm look at what's happening. Family-based green cards are among the most important ways people come together in the United States. Parents, spouses, children, and siblings rely on these petitions to reunite with loved ones. But immigration rules change, and it's vital to understand exactly how. Starting in 2026, USCIS is implementing updates to how family-based green card applications are reviewed. One of the biggest changes is the way priority dates are managed. Previously, families could sometimes see delays that seemed unpredictable. Now, the system will be more structured, meaning some petitions may move faster, while others could take longer depending on your category and country of origin. For example, consider Maria from Mexico, who petitioned for her adult son. Under previous rules, Maria's priority date was expected to advance slowly, sometimes taking over a decade. With the 2026 changes, certain family preference categories will move more predictably, allowing petitioners like Maria to better plan and track when their loved ones might receive their green cards. Another important change involves eligibility verification. USCIS is tightening the review process to ensure that the relationship between petitioner and beneficiary is legitimate. This applies to spouses, children, and parents. If you are filing for a spouse, for example, your marriage must be well documented, with supporting evidence like joint leases, shared bank accounts, or photographs of family life. Simple letters of intent or affidavits may no longer be sufficient in many cases. Let's make this real. Imagine a couple, Ahmed and Layla, married for 2 years and filing for a spouse visa. They had previously relied on minimal documentation because the system was more lenient. With the 2026 rule shift, their application will require comprehensive evidence of their marriage history. Not having proper documents could result in delays, requests for additional information, or even denials. USCIS is also introducing clearer instructions for children-based petitions. For families filing for children under 21, proof of legal guardianship, birth certificates, and school records will become more important than ever. This is designed to reduce fraud, but it means that families must carefully organize paperwork in advance. Processing times will also be affected. USCIS has announced that while some categories may move faster, others could experience longer wait times, especially for siblings and adult children of U.S. citizens. For instance, if a U.S. citizen is petitioning for an adult sibling from a country with high demand, the priority date backlog could take additional years to clear. Understanding this now allows families to plan, save, and prepare documents ahead of time. Fees and forms remain largely the same, but USCIS is emphasizing accuracy and completeness. Incomplete forms, missing signatures, or inconsistencies in supporting evidence could lead to delays. For families who may have previously submitted minimal documents, this is a critical reminder to double-check every page before submitting. Let's talk about another real-life example. David, a U.S. citizen, petitioned for his parents several years ago. When the new rules go into effect, he reviewed his applications and realized that some supporting documents needed updating: proof of income, medical insurance, and legal residence. By acting early, David avoided potential delays or requests for evidence that could have postponed the green cards by months. Travel rules are another area affected by this update. Families waiting outside the U.S. must understand how consular processing interacts with the new priority date system. If you leave the U.S. during the process, re-entry may be affected depending on whether U.S. Citizenship and Immigration Services or the consulate requests additional documents. Planning travel carefully and staying in regular communication with your immigration attorney is now more important than ever. One of the most reassuring points is that USCIS will provide updated guidance and tools online. Families can track their case status, check priority date movement, and see exactly which documents are required. This transparency is designed to reduce confusion and help families avoid mistakes that previously caused unnecessary delays. But here's the key takeaway. Preparation is everything. Families should start collecting all supporting documents now, even if their petition has already been filed. This includes proof of relationship, financial documents, tax records, photographs, letters from friends or colleagues, and any other evidence that shows the genuineness of your relationship. The more organized your file, the smoother the process will be under the new rules. Let me share another story. Fatima, a mother from Pakistan, was petitioning for her children in the U.S. She started early, gathering birth certificates, school records, and evidence of ongoing contact with her children. When USCIS implemented the rule changes, her application sailed through without delays, while other families who waited until the last minute faced requests for evidence and long waiting periods. Planning ahead made all the difference. USCIS has also confirmed that certain humanitarian considerations will remain in place. For example, cases involving urgent medical needs, danger to a family member, or other special circumstances may receive expedited review. Families should always consult with a qualified immigration attorney if they believe they qualify for special processing. Now let's talk about what you should do today to be ready for these changes. First, review your petition and all supporting documentation. Check for missing or outdated forms. Second, organize evidence of your relationship: photos, letters, financial records, and legal documents. Third, monitor your priority date and category on the USCIS website. Fourth, communicate proactively with your immigration attorney if you have one, or consider consulting one if you don't. Fifth, avoid making assumptions or rushing the process. Careful, accurate preparation is now more important than ever. Remember, these changes are not meant to punish families. They are meant to standardize processing, reduce errors, and improve transparency. Families who act early and organize their documentation will benefit, while those who wait until the last minute may face unnecessary stress and delays. Before we finish, one more real-life example. Juan, a U.S. citizen, was petitioning for his adult daughter from the Philippines. When the 2026 rule changes were announced, he immediately gathered all the updated financial documents, proof of cohabitation, and updated correspondence. By the time USCIS reviewed the case under the new rules, everything was complete and accurate. His daughter's green card was approved without delay. Preparation was the key to success. This is a pivotal moment for families seeking green cards. Understanding the 2026 updates, taking proactive steps, and keeping documentation organized will ensure your family can navigate the process smoothly. Knowledge, preparation, and attention to detail are your strongest allies. If this video helped you understand the upcoming family-based green card changes, please subscribe to Legal Focus USA. We provide clear, calm, and trustworthy immigration updates, practical guidance, and step-by-step legal advice to help families navigate U.S. immigration. Thank you for trusting us, stay prepared, and I'll see you in the next update.